Supreme Court, 9-0 unanimous decision just ended gun control in all 50 states, June 2026. Stop everything you are doing right now because what just came out of the Supreme Court of the United States this morning is the most significant legal event in the history of the Second Amendment. And I am not using that phrase loosely. I am not reaching for dramatic language to get your attention. I am telling you with complete seriousness that what happened this morning at the Supreme Court rewrites the entire constitutional framework for gun rights in this country in a way that is more far-reaching, more permanent, and more consequential than anything that has come before it. More significant than Heller in 2008, more significant than McDonald in 2010, more significant than Bruen in 2022. What just happened this morning changes everything, and the number that tells you exactly how significant it is before you even know what the case is about or what the court said is 9-0, unanimous. Every single justice on the Supreme Court of the United States agreed. Now let me tell you why that number matters so much before I get into the substance of the ruling itself. The Supreme Court has 9 justices. 3 of them, Sonia Sotomayor, Elena Kagan, and Ketanji Brown Jackson, have voted consistently to uphold gun restrictions in every Second Amendment case that has come before them during their tenures on the court. These are not justices who have been sympathetic to gun rights arguments. These are justices who have dissented in Heller, who have dissented in Bruen, who have repeatedly and forcefully argued in their written opinions that the government has broad authority to regulate firearms, and the court should defer to legislatures on questions of public safety. These 3 justices have been the most reliable votes against Second Amendment claims in the history of the modern court. And this morning, all 3 of them joined the conservative majority in striking down major gun restrictions. All 3 of them agreed that what states like California, New York, New Jersey, Illinois, Maryland, Massachusetts, Hawaii, Connecticut, Delaware, and Rhode Island have been doing to the Second Amendment, rights of their citizens, has gone so far beyond what the Constitution allows that even the court's most committed advocates for gun regulation could not defend it anymore. When Sonia Sotomayor signs on to not watching a normal legal development, you are watching a moment that historians are going to write about. You are watching the constitutional question get settled at the highest possible level in the most definitive possible way. And you need to understand exactly what was decided, what it means for your rights right now today, and what comes next as states scramble to figure out what they are going to do about it. Subscribe before we go any further, because this story is not over. And the next chapter, which states, comply immediately, and which states resist and try to create workarounds, is something I am going to be covering every step of the way. You cannot afford to miss those updates. Hit subscribe and turn on notifications right now, and let's get into this. The case is called United States versus Henderson, and it was a consolidated case, meaning the court took multiple related cases and decided them together in a single comprehensive opinion. The questions presented to the court covered federal and state gun regulations across a range of restriction types, and the court's ruling addressed all of them. Chief Justice John Roberts wrote the majority opinion, and all 8 other justices joined it. The core holding is this: strict scrutiny, which is the highest level of constitutional review that exists in American law, applies to all Second Amendment restrictions without exception. If you know anything about constitutional law, you understand immediately what that means and why it is so significant. Strict scrutiny is the standard the court applies to restrictions on free speech. It is the standard applied to restrictions on religious liberty. It is the standard applied to racial classifications. It is the most demanding test in constitutional law, and the government almost never wins when a court applies it. Under strict scrutiny, the government must prove that its restriction serves a compelling interest, that the restriction is narrowly tailored to serve that interest, and that no less restrictive means would accomplish the same goal. That is an extraordinarily high bar to clear, and the vast majority of gun regulations that exist in this country today cannot clear it. And then, Beyond establishing strict scrutiny as the universal standard, the court went further and did something that gun owners across this country have been waiting for since Bruin. It identified 5 specific categories of gun regulation that fail constitutional scrutiny and are now unenforceable nationwide. Not in one state, not in certain jurisdictions. Nationwide across all 50 states, effective immediately. The first category is permit-to-purchase systems, laws that require you to obtain government approval before you are permitted to buy a firearm. Illinois had it, Massachusetts had it, Connecticut had it, Maryland had it, New Jersey had it, Hawaii had it, Rhode Island had it. All of those permit-to-purchase systems are now unconstitutional and unenforceable. The court's language on this point, written by Chief Justice Roberts, is worth understanding clearly. The opinion states that the Second Amendment codifies a pre-existing right, and that the government may not condition the exercise of that right on permission, approval, or delay beyond what is necessary to verify eligibility. The default is liberty. Restrictions require the highest level of justification. What that means in plain English is that you have a constitutional right to purchase a firearm, and the government cannot make you beg for permission to exercise that right. A background check to verify that you are not a prohibited person is constitutionally permissible. A permit system that requires you to apply, wait, and receive government approval before you are allowed to exercise your Second Amendment right is a prior restraint on a constitutional right, and it is gone. The second category that the court struck down is waiting periods that extend beyond the time needed to complete a background check. This is going to affect a lot of states because waiting periods have been one of the most common and most popular forms of gun regulation across the country. California had a 10-day waiting period. Florida had a 3-day waiting period. Rhode Island had a 7-day waiting period. There are waiting periods in more than a dozen states. The court's ruling draws a clear and logical constitutional line. States may require a background check. Background checks take time, and whatever time is genuinely necessary to complete the eligibility verification is constitutionally permissible. But once that check is complete and you have been cleared as a non-prohibited person, the state cannot make you wait additional days or weeks before you can take possession of a firearm you have already purchased and already been cleared to own. The additional waiting period beyond background check completion serves no constitutionally adequate purpose, and it is now gone. The third category is mandatory training requirements as prerequisites for exercising Second Amendment rights. States cannot require you to complete a government-approved training course before you are permitted to carry or own a firearm. The court's reasoning here is consistent with the broader logic of the opinion. Training is something the government can encourage, can make available, can recommend. But the right to keep and bear arms is a constitutional right, and conditioning the exercise of a constitutional right on the completion of a government-mandated course is the same category of prior restraint that would never be tolerated if applied to free speech or religious practice. States that required 8-hour, 16-hour, or multi-day training programs as prerequisites for carry permits can no longer enforce those requirements. The fourth category struck down is good cause or proper purpose requirements for carry permits. The remaining may issue jurisdictions. California and certain counties, Hawaii, Maryland, and a handful of others had systems that required applicants to prove they had a special need for self-defense beyond the general desire that every law-abiding citizen has to protect you faced specific documented threats. You had to convince a government official that your individual circumstances justified the right that the Constitution already guaranteed you. That requirement is now constitutionally dead. The right to carry is presumed. You apply, you pass the background check, you demonstrate you are not a prohibited person, and the permit must be issued. No special need required. No convincing government officials of your worthiness. The right belongs to you by virtue of the Second Amendment and nothing else. The fifth and final category struck down is discretionary approval systems, where officials have subjective authority to deny permits based on their personal judgment about an applicant's suitability. All permit systems that survive constitutional scrutiny going forward must be shall issue based on objective, defined criteria. If you meet the objective requirements, age, clean background check, not a prohibited person, the permit must be issued. No official anywhere in this country has the constitutional authority to deny you a permit based on a subjective determination that you are not the right kind of person to exercise your Second Amendment rights. Now let me walk through what this means state by state, because the impact is not uniform, and understanding where you live and what changed specifically for you is the most practically important thing you can take from this ruling. The states that are most dramatically affected are the ones that had the most comprehensive restriction systems, and at the top of that list, you have California, New York, New Jersey, Maryland, Massachusetts, Hawaii, Illinois, Connecticut, Delaware, and Rhode Island. These states had permit-to-purchase requirements, extended waiting periods, mandatory training prerequisites, may issue carry systems, and discretionary denial authority, all operating simultaneously. All 5 of those categories are now unconstitutional. California's 10-day waiting period is now reduced to whatever time is actually necessary to complete the background check, which in most cases is a matter of hours. The Firearm Safety Certificate requirement, which was California's way of imposing a mandatory training prerequisite, is now a voluntary program that cannot be required as a condition of purchase. May issue counties in California become shall issue immediately. In New York, the training requirements under the Concealed Carry Improvement Act are void. Illinois, the state that had perhaps the most comprehensive system of prior restraints on Second Amendment rights in the country, has seen its FOID card system, its 72-hour waiting period, and its various permit requirements struck down simultaneously. New Jersey's permit-to-purchase system is invalidated. These are not minor adjustments to the edges of these states' gun laws. These are foundational elements of their entire regulatory frameworks, and they are gone. The moderately affected states, places like Washington, Oregon, Colorado, Minnesota, Michigan, Pennsylvania, North Carolina, and Florida, had some, but not all, of the struck-down categories. Florida's waiting period is gone. States with training mandates see those mandates fall. States with any remaining may issue elements or discretionary denial systems must convert to shall issue with objective criteria. And the states that are minimally affected are the constitutional carry states, and the shall issue states that already had minimal requirements because their laws were already closer to what the Constitution actually permits. Texas, Georgia, Arizona, Tennessee, and the other constitutional carry states are essentially unchanged by this ruling. Now let me tell you what states are going to do about this, because the ruling coming down does not mean the fight is over. It means the fight moves to a new phase, and you need to understand that phase clearly so you are not caught off guard by what comes next. The response from states falls into 3 categories, and the third category is the one that gun owners in the most restrictive states need to watch most carefully. Immediate compliance is happening in the constitutional carry, and shall issue states that were already close to constitutional. They have nothing to change, and they are saying so publicly. Delayed compliance is the response from states like California, Washington, Oregon, and Colorado, which are acknowledging they must comply but citing the need for 30 to 90 days to update systems, retrain staff, and revise application forms. That delay is constitutionally problematic but practically expected, and gun rights organizations are watching the clock on it. And then there is resistance, which is the response coming from New York, New Jersey, Illinois, Maryland, Massachusetts, and Hawaii. These states are already exploring workarounds, and I want to be very specific about what those workarounds look like so you can recognize them when you see them. They will try to replace permit-to-purchase systems with mandatory pre-training programs, framing it as education rather than permitting. They will try to justify waiting periods as cooling-off periods for compelling public safety interest rather than administrative delays. They will try to convert may-issue systems into shall-issue systems with 20 or 30 difficult objective requirements that functionally recreate the same barrier to carrying that existed before. These workarounds are not legal under the strict scrutiny standard the court just established, and gun rights organizations, including the Second Amendment Foundation and the Firearms Policy Coalition, are already preparing to challenge every single one of them. Strict scrutiny makes these workarounds extraordinarily difficult to justify, and every one of them is going to face immediate litigation. Let me tell you why the 9-cell vote is historically significant beyond just what it means for the immediate outcome of this case, because the unanimity here carries constitutional weight that goes far beyond a simple majority ruling. No previous Second Amendment case was unanimous. Heller was 5-4, McDonald was 5-4, Bruen was 6-3. Every previous major gun rights victory at the Supreme Court was achieved over the vigorous dissent of the court's liberal justices. The fact that Sotomayor, Kagan, and Jackson joined this opinion does not just mean the outcome was unanimous, it means the legal principle being established, strict scrutiny for all Second Amendment restrictions, has been endorsed across the entire ideological spectrum of the court. That makes it far more durable as a precedent. It makes it far harder for a future court to walk back, and it sends an unmistakable signal to every lower court judge in the country that there is no safe harbor in deferring to legislative judgments on gun regulations anymore. Every gun law gets strict scrutiny now. Every gun law has to prove it is narrowly tailored to serve a compelling interest. Most gun laws cannot do that, and every lower court judge in America just got that message from all 9 justices simultaneously. The implications for future legislation are just as significant as the implications for existing law. For Congress, passing new federal gun control legislation under the strict scrutiny standard is nearly impossible for anything more aggressive than a narrowly tailored universal background check system. Assault weapon bans cannot survive strict scrutiny. Magazine capacity limits cannot survive strict scrutiny. Age restrictions above 18 are going to face serious constitutional challenges. Red flag laws without robust due process protections are going to be very difficult to defend. For state legislatures, the era of experimental gun control is over. Every new restriction has to be historically grounded, narrowly tailored, and defensible under the most demanding standard of constitutional review from the moment it is drafted. For gun owners, the constitutional question has been settled as definitively as it can be settled, and the litigation environment for challenging remaining restrictions just became dramatically more favorable. Here's what you need to do right now to protect your expanded rights and take advantage of what this ruling means for you specifically. The first thing is to understand exactly what changed in your state. If you are in California, New York, New Jersey, Illinois, Massachusetts, Maryland, Hawaii, Connecticut, Delaware, or Rhode Island, major restrictions just fell. But the process of those restrictions actually being lifted in practice is going to take some time, and there will be attempts to replace them with workarounds. Know what is now unenforceable and what is still required while states update their systems. The second thing is to exercise your newly recognized rights before states have the opportunity to create new barriers. If you have been waiting to purchase a firearm because of permit requirements or waiting periods, the time to act is now. If you are in a former may-issue jurisdiction, apply for your carry permit under the new shall-issue standard before states try to create new objective barriers to slow the process down. The third thing is to document any attempt by state officials to enforce laws that this ruling has invalidated. If an official tries to make you get a permit that the court just struck down, document everything, file complaints, and contact gun rights organizations. Enforcing invalidated restrictions against citizens is a federal civil rights violation, and it is actionable. And the fourth thing is to support the organizations that are going to fight the workarounds, because this ruling is the beginning of the next phase of litigation, not the end of the fight. Here is the bottom line on what happened this morning. the Supreme Court of the United States issued a 9-0 unanimous decision striking down 5 major categories of gun restrictions that existed in nearly every state in America: permit-to-purchase systems, extended waiting periods, mandatory training prerequisites, good cause carry requirements, and discretionary denial authority are all unconstitutional and unenforceable nationwide as of today. The most restrictive states just lost the core of their gun control infrastructure simultaneously. Strict scrutiny now applies to every Second Amendment case going forward, which means almost every significant gun restriction that has ever been passed is now vulnerable to constitutional challenge. The constitutional question about whether governments can condition the exercise of Second Amendment rights on prior permission and approval has been answered by all 9 justices with a unanimous no. The states that have been the most aggressive in restricting gun rights are going to resist this ruling through workarounds and delays. Gun rights organizations are already preparing to challenge every one of those workarounds in court under the strict scrutiny standard the court just established. And the gun owner who understands what just happened, who knows their rights, who exercises them before new barriers can be erected, and who supports the litigation that is going to enforce this ruling against resistant states, is the gun owner who wins in this new legal environment. Subscribe right now, because next week I am breaking down exactly which states are complying and which are resisting, and how to challenge officials who ignore what the Supreme Court just said. Share this with every gun owner you know, because most of them have no idea this just happened. All 50 states are on notice. Use your rights.